Pro-Vice-Chancellors, members of the Judiciary, friends, good evening. My name is Robin Hickey. I'm the interim head of the School of Law here at Queen's, and on behalf of my colleagues it's very much a privilege to welcome you to this most poignant and most important of events in our school calendar as we honour the memory of our late colleague Professor Stephen Livingstone. Let me extend an especially warm welcome to Stephen's parents, to Max and Flo, to Sister Alison and to Stephen's partner Karen. We very much appreciate your presence with us here this evening. And on behalf of all of us newly arrived from Gatwick Airport, let me extend a warm welcome to Professor Paul Hunt, tonight's speaker, whom I will introduce shortly. The purpose of tonight's event is that we commemorate and celebrate Stephen's work and his commitment to advancing human rights both as an academic and as an activist. In this, as in so many things, Stephen was a pioneer, and long before policy engagement and pathways to impact were ordinary parts of the academic lexicon and experience, Stephen was treading these paths and doing so with considerable success and distinction. During his time as a master's student at Harvard, Stephen took trips to the US South, where he worked in an American Civil Liberties Union Advice Center in Alabama, and there saw the difference that law and an awareness of legal rights can make on the ground. Stephen's passion for human rights was grounded and would later find large measures of expression in exactly these kinds of practical application. Stephen very much believed that respect for human rights must be an integral part of any settlement of the conflict here, and he made a distinguished contribution locally as chair of the Committee on the Administration of Justice and through his work as a member of the Equality Commission. He also travelled extensively, carrying out human rights training and consultancies for such bodies as the British Council, the Council of Europe, the European Union, working with judges, police wardens, academics, police officers, and more besides. South Africa held a particular interest for him, and at a time when Queen's and law schools in general were striving to become more international, Stephen was, again, already at the forefront. Stephen's work continues to have a heavy influence here. His writings remain essential reading for our students, and a scholarship in his name attracts the best and the brightest postgraduate students to Queen's to carry on his legacy of leading-edge human rights work. As I reflect on his broader contributions and to passions which extended far beyond law, to film and to music and to comedy, I can't help but reflect on how much we miss him as a colleague and how much we stand to learn from him and from the way he conducted himself as a peer and a mentor and as a head of school. Stephen appointed me to my first post here in 2003 and almost immediately invited me to lunch, a privilege that he was proud to say, an invitation he was proud to say he extended to all staff. He made time for his colleagues in the office and on the five-a-side pitch, and his presence here, both academically and collegially, was characterised by enormous generosity of spirit, by gentle wisdom, and by unfailing wit and warmth and charm. He is, in every sense of the word, very dearly missed. It is fitting that tonight we honour Stephen's contribution to the field of human rights by welcoming Professor Paul Hunt to deliver the Livingstone Lecture 2016. Like Stephen, Paul's work blends academic rigour and excellence with outstandingly impactful practical contributions to wider society. Paul is currently Professor of Human Rights at the School of Law at the University of Essex and has previously held academic appointments at Waikato University in New Zealand. He has lived and undertaken human rights work in Europe, in the Middle East, in Africa and the South Pacific. And like Stephen, his commitment to human rights has found concrete expression in distinguished practical applications. In the 1980s, he was Legal Officer of Liberty. Between 1990 and 1992, he was Associate Director of the African Centre for Democracy and Human Rights Studies in Banjul, Gambia. In 1998, during his time at Waikato, he was nominated by the Government of New Zealand and elected by the United Nations to serve as an independent expert on the UN Committee on Economic, Social and Cultural Rights. Between 2002 and 2008, he served as UN Special Rapporteur on the right to the highest attainable standard of health. In 2008, in his final thematic report as UN Special Rapporteur, Professor Hunt took a step that continues to spark interest and pay dividends today. He crafted a set of human rights guidelines for pharmaceutical companies in relation to access to medicines. These guidelines, and I'm quoting from the report, set out the human rights responsibilities of pharmaceutical companies in that context. They are the product of wide-ranging discussions spanning 5 years and consider issues such as transparency, management, accountability, patents, licensing, and pricing. The legacy of this report continues to be felt. It serves as a model for rigorous, impactful research, co-produced with stakeholders, and it resonates with much wider debates on the obligations of corporations that remain very much at the forefront of human rights jurisprudence. Ladies and gentlemen, on the basis of even these very brief remarks, I'm sure you'll agree with me that Professor Hunt is a most fitting, most distinguished speaker for this most important occasion, and it's an honour now to invite him to deliver the Stephen Livingstone Lecture 2016, entitled The Right to Health, Context, Operationalisation and Leadership. Professor Paul Hunt.
Thank you very much, Robin. Thank you very much indeed. And good evening. Good evening, friends and colleagues. I'm really delighted, and I feel very honoured to be invited to present the Stephen Livingstone Lecture this evening. I remember Stephen very well and with great respect and affection. He made, as we've just been reminded, he made an exceptional contribution to human rights in these islands, but also beyond. And I remember him as being super smart, compassionate, and funny. And I recall he had a deep sense of social justice. And my topic tonight is a social right, the right to the highest attainable standard of health. And I'm open to correction, but so far as I recall, Stephen did many things, but I don't think he did much work on social rights, but maybe I'm mistaken. But I think his commitment to social justice suggests that he would have been both interested and sympathetic in the issue that I'm going to talk about this evening. In any event, I'm very touched to be invited to make a few remarks in Stephen's honour. Social rights. There are a few challenges when speaking about social rights. First, people often have no idea what you're talking about, at least at the beginning, and I have to say sometimes at the end. But second, in my view, a public lecture on social rights must be multidisciplinary. And multidisciplinarity is not easy. I have painful memories of my first invitation to speak at the World Health Organization. WHO is, of course, an organization of health professionals. But I spoke to them as a lawyer, and I remember the look of sort of polite mystification that fell across their faces as the interminable minutes passed. The problem was that health professionals and lawyers tend to have different premises, different concepts, different language, and I had made insufficient allowance for my audience's profession. For example, when lawyers talk about human rights implementation, they often, not always, but they often refer to the relevant laws, regulations, judicial orders, and so forth. But when health professionals talk about human rights implementation, they often refer to the health policies, the health programs, and other practical health interventions needed to deliver, say, children's access to immunization programs. So different understandings of the word implementation. To give another example, human rights lawyers set much store by the word equality, and they're often wary of the concept and the word equity, whereas health professionals set much store by the word equity and are often a bit worried about the word equality. In fact, lawyers' equality is very close to health professionals' equity, but that needs teasing out. It needs careful explanation. And without explanation, you can soon find yourself in the realm of, you say tomato and I say tomato, let's call the whole thing off. In any event, in my brief multidisciplinary remarks this evening on the right to health, I'll try to speak to different disciplines, and it's tricky, and I therefore apologise in advance if I don't get it quite right. The right to health is a social right. Well, what is a social right? We all have familiarity with civil and political rights, such as the prohibition against torture, freedom of speech, the right to a fair trial, and so on. But another group of human rights, social rights, are neither well known nor well understood. Social rights include the rights to education, basic housing, food, the right to an adequate standard of living, and the right to the highest attainable standard of health. I'll probably use the shorthand, the right to health. Although civil and political rights are better known than social rights, all three groups of rights, civil, political, and social, have the same importance, the same status in international human rights law. While the three groups of rights have the same international status and the same importance, there are significant differences between them. For example, civil and political rights, like freedom of speech, civil and political rights have to be implemented immediately. But social rights may be realised progressively over time. So take the right to health, for example. This is a large and complex social right with many features. It requires a government to establish an equitable health system. It requires a government to establish an effective sanitation system. Obviously, such features cannot be constructed overnight. They take years, they take decades to put in place. And the right to health recognises this. It places an obligation on governments to progressively realise the right to health over time. But that doesn't mean a government is free to do whatever it wants, so long as it's broadly going in the right direction. The right to health requires governments to prioritise measures that are the best available to them, taking into account the epidemiological evidence, resource availability, and other human rights considerations. Now that's quite a mouthful, that's not a simple formula, and there will be honest disagreements about what to prioritise. And this is why constructive accountability for the right to health, which I will come back to later, that's why constructive accountability is so very important. For now, my main point is that social rights may be progressively realised over time, while civil and political rights may not. And in my view, making social rights, such as the right to health, subject to progressive realisation makes a lot of sense, although it does complicate matters. Can I make a few comments on social rights and, quote, left behind communities? As we meet, the United States of America goes to the polls, as we all know, to decide whether Donald Trump or Hillary Clinton will be the next president of the United States. Here in the UK, the media is full of Brexit. And I suggest there is a link between Trump, Brexit, and social rights. Right-wing populists, such as Donald Trump and Nigel Farage, exploit the disaffection of the disempowered. Their campaigns gain strength from widening inequality, poverty, and a sense of unfairness. And this is similar, I don't say the parallel is precise, but it's similar to what happened in the 1930s. After 1945, lessons were learned from the disastrous 1930s, and these vital insights shaped the United Nations as well as social contracts in many countries. But it worries me that we may have forgotten some of these lessons. In the aftermath of the Second World War, the international community grasped that human rights are needed as safeguards, not only against authoritarianism, Nazism, but also human rights were needed as safeguards against the causes of authoritarianism, inequality and poverty. And in 1948, the United Nations adopted the Universal Declaration of Human Rights. This was a colossal achievement, and it encompasses civil and political rights, which are designed as bulwarks against authoritarianism of the left or the right. But the Declaration also includes social rights. And social rights were there designed to eliminate the causes of authoritarianism. Causes such as poverty, inequality, and gross economic disadvantage. Combined together, civil, political and social rights form a decency threshold below which nobody should be allowed to fall. This, it seems to me, was a profound insight and a profound contribution of the post-1945 international settlement. But in contemporary United States of America and in the UK, I suggest that social rights have been neglected. Consequently, within the US and the UK, there are deep pockets of disadvantage. There are left behind communities. It seems to me that their sense of alienation has contributed to the rise of Donald Trump, as well as the UK's decision to leave the EU. Of course, the picture is very much more complicated than I have conveyed. Of course, some Trump supporters and some of those who voted to leave the EU are neither disadvantaged nor disempowered. My point is that, to one degree or another, the Trump and Farage campaigns benefited from the alienation experienced by some marginalised individuals and communities who felt left behind. And I suggest that better recognition of social rights, as well as civil and political rights, would have taken the wind out of the sails of Trump and Farage. Let me go back to the right to health. Where does the right to health come from? The right to health is grounded in the Universal Declaration of Human Rights. It's set out in numerous legally binding treaties, and it's enshrined in numerous national constitutions across the world. But the right to health is not only in these legalistic lawyers' documents. The right to health is also in important documents drafted and agreed by health professionals. For example, the right to health is in the Constitution of the World Health Organization. It's in the important health document, the Declaration of Alma-Ata. It's in the Bangkok Charter for Health Promotion, and so forth and so on. The Bangkok Charter, by the way, not only affirms the right to health, it says health promotion is based upon the right to health. Now, not long ago, I gave another talk in Belfast, and when I explained that both the United Kingdom and Ireland are legally bound by treaties that include the right to health, I'm not kidding, someone in the audience exclaimed, "That must be the best kept secret in this island." In the UK and Ireland, the human rights focus has been on civil and political rights. Hence, for example, the UK's Human Rights Act, which, by the way, the administration of Theresa May wishes to repeal and replace with a so-called British Bill of Rights. However, the Human Rights Act, I suggest, is misnamed. It's not an act of human rights, it's an act of civil and political rights. It's true that the distinction between civil and political rights and social rights is blurred, and it's true that civil and political rights can be used to enhance some aspects of social rights. But nonetheless, the Human Rights Act is first and foremost a catalogue of civil and political rights, not all human rights, and therefore its title is a misrepresentation. In our islands, social rights, such as the right to health, have been neglected. There are several reasons for this, and I'm going to briefly consider a few of them in a moment. But for whatever reason, the existence of the binding international right to health is not well known. And in my view, this is a travesty, and it represents a missed opportunity. It seems to me that it's profoundly wrong that our representatives fly to the United Nations and to other international bodies and say they agree to social rights, and even sign up to legally binding treaties that include social rights, and then remain silent about them when they get back home. Social rights, including the right to health, should be part of our collective debate. Of course, they do not provide easy answers to difficult policy issues, but they have a contribution to make. Happily in my view, but not in everyone's view, happily there are a few signs that social rights are beginning to enter our discourse. To give just one example, Nicola Sturgeon has explicitly affirmed the importance of social rights, and we'll have to wait to see what this might mean in terms of policy and practice. When talking about and reflecting on these issues, I find it useful to keep in mind two different approaches to human rights. One approach to the vindication of human rights is, of course, via courts, tribunals, and other judicial processes. An exceedingly important approach to human rights. Let's call it, as a shorthand, the judicial approach. There's another approach which brings human rights to bear upon policies, programs, and practices. Let's call that the policy approach. The policy approach aims to integrate human rights into policy-making processes. In this way, human rights shape policies, programs, and practices. The policy approach does not entail going anywhere near a court. On the contrary, an effective policy approach will keep policymakers out of court. Adoption of a policy approach has far-reaching implications. For example, if we wish to use the policy approach to deliver the right to health, we cannot do this without the skills, knowledge, expertise, and commitment of health professionals. Of course, the judicial and the policy approaches are intimately related and they're mutually reinforcing. But nonetheless, I think the distinction is important because the policy approach opens up challenging new multidisciplinary possibilities for the operationalization of human rights. And it's mainly with the policy approach in mind that I make my remarks this evening. Back to the right to health. What is the content of the right to health? What does it mean? I'm just going to give you a sketch outline of some of the key features of the right to health. Very briefly, the right to health not only includes medical care, it includes that, but it not only includes medical care, it also encompasses access to safe water, adequate sanitation, a safe working environment, access to health-related information and education, and other what are called critical preconditions of good health. It places an obligation on government to give particular attention to the disadvantaged, to disadvantaged individuals, communities, and populations. It requires government to put in place arrangements that facilitate, so far as possible, the active and informed participation of those affected by health-related policies and programs. As already discussed, the right to health is subject to progressive realization. No government is expected to realize it overnight, but to progressively work towards its realization. And this means that we need indicators and benchmarks to measure whether or not progress is being made. Crucially, the right to health is subject to resource availability. In other words, more is demanded of the United Kingdom and of Ireland than it is of Sierra Leone. Accountability is a crucial element of the right to health. It seems to me that too often today the same body is responsible for delivering and regulating health-related services, as well as holding those responsible to account. And from the right to health perspective, this is problematic. When I talk about accountability, I'm not talking about blame, sanction, and punishment. I'm talking about what the books call constructive accountability. That is, a process that takes human rights standards into account and then identifies what is working so it can be repeated and what is not so it can be revised. What is the profile of the right to health within states? Of course, I can't answer that in its entirety, but just a couple of reflections. On the positive side, there is evidence that some states, Italy, Brazil, Nepal, Malawi, some states are explicitly using the right to health to shape their policies. That doesn't mean they always get it right, but they're using the right to health in their policies. And really importantly, there's now some evidence that these human rights shaped interventions are contributing to health gains for individuals, communities and populations. Please notice I said that the human rights shaped interventions are contributing to health gains. I didn't say human rights shaped interventions are causing health gains. This is a difficult causation issue which has to be treated very, very carefully. But there is now evidence that human rights shaped interventions contribute to health gains. The WHO monograph of 2013 on women's and children's health, evidence of impact of human rights, and other publications as well. Also, some right to health litigation has had a significant impact in some countries, such as leading to systemic reform of the health system in Colombia and leading to improved access to antiretroviral drugs in South Africa. In the UK, there have been some right to health or health rights initiatives in recent years. For example, Scotland's State Hospital has introduced a human rights-based approach, and there is evidence, independent evidence, that both patients and staff have benefited from that human rights-based approach. More recently, NHS Health Scotland has taken steps towards a better integration of human rights into its work. As some of you may recall, last year the Northern Ireland Human Rights Commission concluded its human rights inquiry into emergency care. The inquiry's substantive report sets out a human rights-based approach, and as I understand it, some health and social care trusts in Northern Ireland are now taking steps to advance a human rights-based approach in relation to their provision of emergency care. And these are very welcome developments. I hope that if there are people here who can speak about these new human rights and emergency care initiatives, I hope they will share their experiences, if they wish, during discussion. In a recent issue of Harvard's Health and Human Rights Journal, Lindsay Dyer has explored the impact of the Human Rights in Healthcare programme, which has been instituted in England and Wales. In South London, a whole group of NHS Foundation trusts have got together and recently launched a 3-year human rights-based project for especially disadvantaged communities in South London. I could go on. This is not a complete survey, not at all, of health rights work within the UK. I have the impression, maybe I'm misreading it, but I have the impression there is a growing interest in the right to health in the UK. Just this morning, I was invited to speak at the annual conference of the Association of Public Health Directors. And that request has been a long time waiting, but it's now been made. And to me, it signals that that important body and their members are beginning to look more closely at the right to health. Now, all of those involved in these initiatives that I've briefly signalled, they're pioneers in the United Kingdom, and they deserve great credit. But nonetheless, the right to health in the UK urgently needs much more operationalisation, many more critical friends, and more high-level champions. And I have to say that in my experience, looking overall, the right to health has gained only limited support in the United Kingdom. It seems to me, for the most part, the right to health is not explicitly shaping health policies and programmes. Within the UK's community of health professionals, the right to health continues to have a low profile. If I'm right about this, why is this? Since the year 2000, across the world, there has been a huge increase in literature reports, guidance, court cases, and so forth on the right to health. Among the literature is some UN technical guidance on how to operationalise health rights, how to operationalise health rights in relation to HIV, how to operationalise health rights in relation to maternal mortality, how to operationalise health rights in relation to under 5 mortality, how to operationalise health rights in relation to contraceptive services and information. And this technical guidance is quite practical, quite specific. So why is there not more governmental action using the explicit language of the right to health in the UK, and for that matter, in other countries too? What are the possible explanations for this? Well, there are many. I'm just going to mention 4. Your views on them and other possible explanations will be very welcome. So, first, candidate explanation as to why there is not more governmental action explicitly on the right to health. Well, one explanation is that there is not yet a compelling account, a compelling philosophical foundation, a compelling justification for the right to health. I've got 2 problems with that as a candidate explanation. One, I'm not sure that it's true. It seems to me that over the last 10, 15 years, we now have a number of reasonably coherent philosophical accounts or justifications for the right to health. Some are based on equity, some are based on social interest, some are based on capabilities, and so on. I find personally the latter, capabilities, especially compelling as a foundation for the right to health, based on the scholarship of Amartya Sen, Martha Nussbaum, Ruger, Ram Thiktin, Venkatapuram, and others. So I'm not so comfortable with this first candidate explanation, that we lack a philosophical justification for the right to health. I think we did 20 years ago. I no longer think that we do lack that. The second problem I have with that candidate explanation is that I've never discussed the right to health with a health policymaker or a health practitioner who has objected to it on the grounds that the right to health is philosophically incoherent. Of course, I accept that more work is needed on the ethical foundations and justification of the right to health, but I'm not yet persuaded that the further advancement of the right to health depends upon this work being done. What's the second candidate explanation as to why there is not more governmental action explicitly on the right to health? Well, one other explanation is this. It's in the books and one hears it in discussions and debates, that there is not yet a consensus around the content of the right to health. Now, I accept there isn't yet a consensus on the content of the right to health, and I accept that more work is needed on content and scope of the right to health. But when approaching the content of the right to health, or indeed the content of any human right, I do not think that consensus is the correct approach, for a number of reasons. One, consensus will drive us to the lowest common denominator. 2, a consensus approach does not sit comfortably with the claims of minorities, which are a particular preoccupation of human rights. 3, a consensus approach favours those with voice, space, agency, authority, and power. Social rights have a special importance for those living in poverty. Those living in poverty do not have voice, space, agency, authority, and power. Thus, a consensus approach will reflect and further entrench the disadvantage of those living in poverty. Of course, the content of the right to health must be clear, it must be credible, coherent, realistic, and feasible. And it must have a sufficient measure of legitimacy, but not by way of consensus. I tend to favour a consensus on the essential principles and a consensus on a right to health framework, and then the appointment of a diverse and accountable group of independent people to develop the content of the right to health by way of a dynamic process that includes the active, informed and meaningful participation of those living in poverty. Third candidate explanation as to why there is not more governmental action explicitly on the right to health. And if you're uncomfortable with some of the earlier comments, you might be uncomfortable with this. The third candidate explanation is that the prevailing economic orthodoxy is neoliberalism, and the enjoyment of social rights is incompatible with this economic orthodoxy. One of the people who's written most about this is Paul O'Connell. Paul O'Connell and others take this position, and I find it increasingly compelling. The values informing the right to health include equality, non-discrimination, equity, participation, transparency, accountability, empowerment, a sense of solidarity, and the dignity and well-being of all individuals, communities, and populations. These values, as often used in the human rights discourse, I suggest, do not resonate with the values driving neoliberalism. As I understand it, there is evidence that neoliberalism has helped to lift many people out of poverty. But there is also evidence that neoliberalism has impoverished many, left many communities behind, and widened inequalities. I suggest that the influence of neoliberalism is not the only reason, but one of the reasons why some governments are resistant to social rights, including the right to health. However, if I am correct about this, it must not serve as an excuse not to advance, as far as we can, the right to health. For example, even if that argument is correct about neoliberalism, for example, greater clarity is needed about the content and scope of the right to health. A fourth candidate explanation for why the right to health does not have a higher profile. At root, human rights are a normative enterprise, whereas health professionals are trained to esteem evidence. Health professionals want evidence that an intervention saves lives or reduces suffering. They are more likely to be persuaded by evidence that an intervention saves lives and reduces suffering than they are by a normative argument. Yet the human rights community has been slow to marshal evidence of impact of human rights, a shortcoming that is now being addressed in some quarters, as I've explained. Of course, the question of evidence is a really complex endeavour, raising important issues of epistemology and attribution and association and causation. But if we wish health professionals to take human rights seriously, I suggest we need to deploy normative arguments, of course, but supplemented by evidential arguments. By way of conclusion, 4 pretty short points. The last 2 explicitly entertain your critical feedback. If not in Q&A, that's up to our chair, then after this event, if you wish. So 4 relatively short points. by way of conclusion. First, I suggest it's very important for multidisciplinary, they must be multidisciplinary, for multidisciplinary teams to collaboratively work together and figure out how to operationalize the right to health in relation to specific manageable health issues. And if you'd like more details on that, then please take a look at the Northern Ireland Human Rights Commission inquiry report on emergency care published last year. So that's one of my 4 conclusions. The second is this: high-level leadership is vital if we are to advance the agenda of the right to health. Leaders have to signal that they want the right to health and other health rights to be taken seriously. Right to health work should not be smuggled in below, as it were, the radar. Leadership should give space and legitimacy to this important human rights work. My penultimate concluding remark, a little bit longer, but my penultimate concluding remark is about language. It's about language. And this is a really sort of practical problem that I'm often encountering, and I would appreciate your counsel on it and what you think about it. Let me try and explain. If you look at the health policy documents of many countries, the explicit profile of the right to health in those policy documents will often be low or non-existent. And I've already touched upon this. So if you then say to the relevant health professionals in a particular country where the health policies don't explicitly mention the right to health, if you say to them, your government has signed up to the right to health, why is this human right not mentioned in your policy documents? If you say that, the answer you are likely to get is the right to health is not explicitly mentioned in our policy documents, but it is implicitly integrated into the relevant policies. Let's just assume that this is entirely accurate, that the right to health is implicitly integrated. Let's just assume that. So in other words, let's assume that key right to health elements are reflected in the relevant health policies. It's not always the case, but let's just assume that is the case. Let's assume the right to health considerations, such as equitable access for all, such as good quality health services. Let's assume right to health considerations are in these policies, but without explicit reference to the right to health. My question is that acceptable? Is it acceptable for the right to health to be implicit and not explicit? And I would genuinely be very interested to know your opinion on this, because it often arises in practice. You might disagree with my view, but I'm now going to share it with you. I can do so briefly. First, I accept that in some countries, in some contexts, it might be sensible and expedient to adopt the implicit approach. I can see that. Second, in my view, I don't think the UK falls into that category of country. The UK remains a democracy. It has signed up to all the international treaties that include the right to health. It accepts the right to health in Geneva. There is no excuse for it to bury or disguise the right to health when it comes back home. Third, if the right to health is only present implicitly, those in authority, that is the duty bearers, that is the policy makers, they're in a very powerful position. They know if and when the right to health was in their thinking. They know what they understood the right to health to mean. They know how it was integrated and applied in the relevant policy. But the rights holders are in the dark. So the implicit approach makes it difficult for the rights holders to hold the duty bearers accountable in relation to the right to health. And my fourth point is that the language of rights empowers rights holders. To be a rights holder feels different from being a service user. But this sense of empowerment that comes from the language, the words of rights, that sense of empowerment is lost if the implicit approach is used. So, seriously, feel free to disagree, but that's my view, and I'd be interested in yours. And now my last concluding remark. This fourth and last concluding observation, I've not discussed in public before, and I do so now with some trepidation, but I would welcome your feedback on it. I wonder if the time has come for the preparation of a social rights manifesto in the United Kingdom to steer policies, programs, and practices. Such a social rights manifesto would include the right to health, as well as other social rights, the right to shelter, the right to education, and so forth. In my view, it should be prepared by way of a bottom-up participatory process, not a working group of lawyers sitting in our capitals. I strongly favour justiciable social rights. I haven't explored that argument in these remarks this evening, but so there's no misunderstanding, I strongly favour justiciable social rights. But the Social Rights Manifesto would not be justiciable. It would provide compelling authoritative guidance on these neglected social rights. Although not justiciable, the manifesto should be subject to non-judicial forms of accountability, for instance by national human rights institutions, by specially designated select committees of national legislatures. Possibly local authorities could also establish a body, if they so wished, to hold duty bearers accessible in their geographical area in relation to the social rights in the manifesto. When it comes to accountability for social rights, we need to be inventive. I think and hope that Stephen would second a plea for inventiveness. Thank you all very much.